lesbian, gay, bisexual, transgender, queer, and other permutations of sexual orientation and gender identity are explored in this module. About 6% of the adult population in the U.S. identifies as part of the LGBTQ+ community. It is a very broad grouping that includes at least 5 and certainly more distinct populations. Someone who identifies with this community may be of any race or culture and may have one or more disabilities. Note that in this Gallup survey, the lesbian population and transgender population are about the same. The gay population is twice as large, yet the bisexual population is yet twice that of the gay population, and over 50% of the people who identify as part of the LGBTQ+ community. However, how that population breaks out varies significantly among the different generations. The most striking data point on this table is the dramatic increase in the number of people who identify as bisexual, from 0.3% among the traditionalists to now over 11% of the current population. For most of our history, consensual same-sex relations were considered a crime. Many states criminalized LGBT sexual relations through what were known as sodomy laws. Illinois was the first state to repeal its sodomy statute in 1961, and nearly 24 states did so in the 1970s and the 1980s. In California, the legal fight was drawn out over multiple years and culminated in 1975 with a dramatic tie-breaking vote in the Senate by the California Lieutenant Governor. In 1986, the Supreme Court validated these state sodomy laws in the case Bowers v. Hardwick. But 17 years later, the Supreme Court reversed itself in 2003 in the case Lawrence v. Texas. This case overturned and invalidated all of the state laws related to sodomy, laws that were used to persecute and prosecute gay, lesbian, and bisexual people. As committed as states were to prohibiting same-sex relations, they were even more committed to prohibiting same-sex marriages. And the same was true for the federal government. In 1996, President Bill Clinton signed the Defense of Marriage Act, known as DOMA, D-O-M-A. This act wrote into the federal code the definition of marriage as, quote, only a legal union between one man and one woman as husband and wife. DOMA further provided that states did not have to recognize same-sex marriages from other states, essentially attempting to write an exemption into the 14th Amendment. After the federal government adopted DOMA, 40 states enacted similar legislation. But in 2013, the Supreme Court struck down DOMA. Then, even more dramatically, in 2015, the court issued the landmark Supreme Court case of Obergefell v. Hodges. On a 5-4 vote, the Supreme Court granted the right to marriage of same-sex couples. Prior to this court case, 3 states, beginning with Massachusetts in 2003, permitted same-sex marriages based on state court rulings, and then in 2009, Vermont was the first state to legislatively approve same-sex marriages. Maine, in 2012, was the first state to approve same-sex marriages by voter referendum. While the civil rights laws of the 1960s generally prohibited discrimination based on sex, it was not accepted that the term sex also encompassed sexual orientation or gender identity. President Obama's administration began an effort to so interpret the law, but the effort was discarded by the Trump administration. In June 2020, however, the Supreme Court issued another landmark ruling that Title VII protections relating to sex extend to sexual orientation and to gender identity. The groundbreaking case was Bostock versus Clayton County, Georgia, the opinion for which was authored by Justice Neil Gorsuch, with a quote shown in this slide. The still unanswered question is to what extent this interpretation will be extended beyond employment and beyond education under Title IX and extend into public accommodations. It also remains an unanswered question as to what extent private businesses will be able to discriminate against the LGBTQ+ community based on their religious convictions. One of the most significant transgender cases is out of Virginia, Gavin Grimm versus Gloucester County School Board. Gavin Grimm, a transgender male, sued the school board under Title IX for excluding him from the restrooms that other males in the school used. His case illustrates the challenge of achieving one's rights through the courts. Grimm's case began in 2015, but it was not until July 2021 that the case finally came to a close. And at that time, the court ordered the Gloucester County School Board to pay $1.3 million for Grimm's attorney fees and expenses. Although he had long graduated, Grimm prevailed in the end, and a new precedent was set for transgender youth. The extra-legal injustice and violence that we have seen used against other populations has been waged against people in the LGBTQ+ community as well. For 2019, the FBI reported almost 1,200 hate crimes related to sexual orientation and another 200 related to gender identity. While these are significantly fewer hate crimes than those committed based on race, ethnicity, or religion, they are very high given the relative size of the LGBTQ+ community. Among the more horrific examples is the 1990 case of Matthew Shepard, a 21-year-old student at Wyoming who was beaten, tied to a fence, and left to die. His attack was clearly a hate crime. More complex is the 2016 mass shooting at the Pulse nightclub in Orlando, Florida. 49 people were killed and 53 wounded, most of them members of the Latinx members of the LGBTQ community. This case further illustrates the complexity of intersectionality. Was the attack on Pulse an act of terrorism unrelated to ethnicity or sexual orientation? Or was it an anti-LGBTQ+ hate crime, or a Latinx hate crime, or some combination? These issues remain in debate. What are the real facts? And, regardless, what are the feelings and the lingering traumas?